Right,
And
we're live.
I believe you are.
Looking
Go
clear.
ahead.
Thank you, Tracy, for your administrative support. Morena Koto, good morning, everyone. Welcome to this morning's briefing of the Kaipara District Council. This is a briefing for the District Plan Review, which of course is setting the rules for what is going to be taking place for land use across Kaipara District. For this morning, I am going to open this morning's District Plan Review briefing with a karakia. Kia horo te marino, kia whakapapu painamu te moana, hei ho rahi ma tātou I te rangi nei, aroha atu, aroha mai, tātou ia, tātou katoa. And I have to say that yes, the water is like greenstone this morning. It's very, very still and beautiful on both the harbours of beautiful Kaipara District today. So it's a lovely, lovely early summer's day. For today's briefing, we have two apologies. Councillor Erin Wilson-Collins is unable to join us, and Councillor Karen Joyce-Parkey is also unable to join us. They both have other professional work commitments today, so unfortunately can't be joining us. But all of the other councillors are present, and I'm here as well. And we are joined by a very capable team of experts who are going to be taking us through our briefing this morning, and we're going to be led today by Michael Day. So kia ora, Michael. Morena, if you could turn on your camera and please take the lead for today's briefing for us. Thank you.
Thank you, Your Worship, and very good morning, team elected members. Catherine Overwater will be sharing her screen, and we'll take it from there. Thank you. You're right, this is the last District Plan Review briefing of the year, and we'll look forward to a very interesting and informative session today. So what we're going to cover off this morning is the hazardous substances topic, which will be led by Catherine Overwater, with technical support, if needed, by Norbert Chauffeur. The contaminated land section will also be led by Catherine, and then Ian Mayhew from Foresight Consulting will lead the natural hazards and climate change work with support from the Kaipara District Council team as well. Following that, we will have a brief opportunity to discuss the direction that elected members gave staff last briefing, which was the November briefing. Thank you, Catherine. Next slide. I won't dwell on this. We've all seen this before, and the idea is to obviously get through all the material, and hopefully the elected members will start to be able to conceptualise the look and feel of a new district plan. Thank you, Catherine. Next slide. And one more. Right, here's the timetable. Well, what we've got in front of us here is essentially, sorry, Catherine, if you can go back one slide or just touch on the, thank you. So as I just touched on, today is our last briefing prior to the Christmas break. Then there'll be another 3 briefings next year, February, March and April, where the team will then bring the whole draft district plan back in front of elected members. And in May, we will be seeking approval to engage with the public on the draft district plan at the May Council meeting. Any questions before we carry on? Awesome. Let's get into it. Next slide, please, Catherine. And it's all yours, Catherine. I'll hand you over to Catherine.
Thanks, Michael. So I'm going to start with the ambulance at the bottom of the cliff, which is contaminated land. And then I've got just slight correction to name Norbert Chauffeur, who, Norbert, are you there? Would you like to just pop your camera on for a sec to make yourself known? And
hello, Morena.
Norbert's joining us all the way from Auckland, and he is our expert for the hazardous substances topic. So I'm going to run through very quickly the contaminated land matters, and then we'll spend a little bit more time on the hazardous substances. So, Right, so contaminated land is mostly regulated under the National Environmental Standards for assessing and managing contaminants in soil to protect human health regulations from 2011. And councils are pretty good with this stuff now. We've had it for a long time, and while we do have a function under Section 31 of the Act, we don't generally include rules in the district plan around this now. So you'll see in the material that I've circulated to you in the agenda that we've just focused on some objectives and some policies. Now I'm going to, through your worship, just take those agenda items as read to speed through today's content, but I have put some slides together, of course, with those on there. So I'm certainly happy to take any questions on those, but I think the key point here is really that council's role when there's subdivision use and development in this space regarding contaminated land is that we look at this through the resource consent process, and we identify whether a preliminary site investigation is required, and that will determine how contamination in soil is dealt with by council. And often what we do is we require contamination reports and remediation advice from experts in this space. And Wendy's team will be across what happens there. But really for the district plan review going forward, it's just a case of acknowledging that we do still have a function and a role to play, but largely the legwork is done through the national environmental standards. So I'm not going to dwell on this one too much, but if anyone's got any questions on contaminated land.
Catherine, Deputy Mayor Anna Curnow has her hand up. Yep.
Yes.
Yeah, I'm sure you've got a really good answer for this, but it just came up to me when I was reading the material. Potentially contaminated land. How do you know when something is potentially contaminated? So what are the criteria?
So we do have a lot of what we call hail sites. So those are our hazard and industrial, what's the term, hail. It's got a technical term. So we have those are mapped by the regional council. So if it comes up as a hail site, that's usually a bit of a clue. Sometimes you won't necessarily know. So the NES does require that assessment for any change of land use activity or for subdivision. As part of the requirements around that, they will usually do what's called a PSI or preliminary site investigation report as part of that to determine whether it is in fact contaminated land or not. And just some examples of that, particularly around Kaipara, are things like old sheep dips. Orchards are a prime suspect, and sometimes when there's been storage of fuel, for example, or heavy fertilizers and things like that. So there are often clues as to what will constitute a hail site or a potential contamination. So yeah, usually as part of that process, when there's a land use application or a subdivision, as part of that process, the planners need to go through those steps and make sure that they are in fact compliant with the regulations in the NES. So does that answer your question there?
Yes, it does. Yes, it does. Thank you.
Councillor De Lavaris Woodcock.
Thank you, Catherine. Similar question, but different angle. The use of farm rubbish holes, are they requested or is it compulsory for those sites to be mapped or, you know, marked on for the same subdivision process, or just as a matter of course already?
Yeah, so if they're known, they'll already have been reported to the regional council and put on their map. And so you can check out what they have on there. They actually have quite a number across the Kaipara district. But most farmers or people that live rurally may have historic dump sites, and so you might not necessarily know that until you actually come to do earthwork. So it depends. If you already know, great, you can obviously report that to the regional council and get it mapped, or find a solution to remediate it and dig it out. Yeah, so it just depends on whether you're needing to do work in that space where these things exist. But yeah, so that they do exist everywhere. It's just whether or not they're reported or not, Councillor. So some will be and some won't be, and there is a lot of that across New Zealand as well as Kaipara.
Thank you. Councillor Vincent.
Thank you, Mr. Mayor. I guess my concern with this section overall, like the morning session generally, is are we duplicating what another authority such as the Regional Council or the Environmental Protection Agency or whatever already has to administer? Like, I really hate, I mean, either we do it or someone else does it. If we have to do it, okay, does that mean then that someone doesn't have to apply for the same purpose to another agency for the same thing? So that is my concern. How do we deal with that?
Thank you, Councillor Vincent. So I have prepared a bit of a response to that, particularly in respect to the hazardous substances. So we will get to that in just a moment because there are some more technical aspects to the hazardous substance management. But what I would say in regards to contaminated land while we're on this topic is that we're not duplicating a function of the Regional Council here at Council. We have our obligations under the National Environmental Standards to undertake assessment. The Regional Council will have their functions as far as discharges and their policies and rules, and the regional plan are very clear about their functions and roles. So in respect to contaminated land, I think the functions are quite clear. But when we get across to the hazardous substance topic, which Norbert and I will take you through, there is some overlaps, shall we say, between the legislative functions. So perhaps if I can move into that, that might help just explain some of those functions in terms of what council do and the duplication between regulations and legislation. Are you okay for me, Your Worship, to continue with the hazardous substance discussion?
So yes, but just while we're just still in this moment of talking about the overlaps, I guess the issue is, how does our district plan reflect all the rest of those other changes that may be there and be, if you like, reflexive in that space, but not have to actually prescriptively itself go and have to be changed by any future decisions if there are other cascade of decisions made. So I'm trying to make sense of that. You know, someone else makes a decision. How do we just have a document that lines up with that automatically?
Yeah, so I think in respect to contaminated land, it's certainly not so much of an issue because of the regulations that apply to contaminated land. Remember, this is about the land that's already been contaminated by, for instance, a hazardous substance. So when we're talking about hazardous substances, we're talking about the ambulance at the top of the cliff before the contamination occurs. So just want to get that clear in your minds so that we're clear on what we're talking about in respect to the roles and functions that council has to play here. So when we talk to hazardous substances, I think it will become clearer. But just in regards to the contaminated land, both Regional Council and Kaipara District Council have functions in this space in terms of our Section 31 of the Resource Management Act. So we can, request developers provide this information, make sure that they're meeting the National Environmental Standards regulations. So if they're not willing to remediate or manage the contaminated land, which will pose a risk to any future development. And a good example of that is a subdivision where you've got people building vegetable gardens over the top of, for instance, contaminated sites. And that's something obviously that we don't want to see happen. So we have function to obviously go that far. Hazardous substances is a little bit different, but we still need to just decide as council, and that's what I'll be seeking your direction on today, how far we go in this space. So it might be good if I move into that space and we can talk about the complexities around that before we decide, is this something that Kaipara District Council wants to do or not, because we have some choices there. So it's not not necessarily straightforward. So through you, Your Worship, if you would like me to just take us through that.
So keep us
can...
moving, Catherine. Thank you. Yeah.
All right. I'll just pop my presentation back up here. Alrighty. So if there's any comments on what I've put forward in terms of the objectives and policies around contaminated soil and land, do let me know. But they should be fairly straightforward and they're not inconsistent with what other councils are doing in that space. So on hazardous substances, and this will come back to your question, Councillor Vincent, in the space of hazardous substances, and just let me know if I'm losing anybody. But there are three key pieces of legislation in this space. So we've got the Hazardous Substances and New Organisms Act, which we've talked about in the context of genetically modified organisms, but the HAZNO Act is primarily the one that is where products and chemicals and hazardous substances gain approval for the type of substance, etc., that they are. And then we've got the Health and Safety Work legislation, which is about how those substances are used in the workspace. So, so two very key pieces of legislation, and then obviously the other consideration is the Resource Management Act. Now, the government did something quite interesting in 2017 and removed council's explicit function under Section 31 to manage hazardous substances. So this leaves us in a little bit of a space where we need to decide, or sorry, I should say, elected members need to decide whether they want to proceed in this space or not. But I'm going to give you some good context to that before we get into that. So just remember that we still lean on Section 5 of the Resource Management Act. And while Section 31 has replaced, taken out the explicit function, we still have a general broad function to look at integrated land use. So making sure that we're controlling and managing any actual and potential effects at a more broad level. So while hazardous substances is not explicitly listed there anymore, we still have an obligation to make sure that we manage any potential or adverse effects. So Section 5 is probably the key one. You'll see in the handout that I've circulated to you that Section 5 obviously accounts for people's health and safety and environmental values as well. So that's probably the key one that I'll bring this topic back to, because I think the decision that needs to be made today in terms of direction is whether we feel that, you know, doing something in the space, you know, are we looking after the people of Kaipara by making sure that we have something in the plan, and if we do not, what the risks and consequences of that are. So I'm just going to take you through the 5 key points on this slide, which is that there are some gaps and overlaps. So what we're trying to not do here is duplicate the legislation. And so to be really clear, we don't want to rewrite anything that's written in the HAZNO Act or Health and Safety at Work legislation. This needs to come purely from a land use management perspective in terms of the Resource Management Act and meeting Section 5. So there are 5 factors that myself and Norbert have been working through in terms of preparing the draft provisions for today's workshop. And those are to manage any land use patterns or sensitive environments. So thinking about what the consequences of having hazardous substances could be on those sensitive environments. If we were, for instance, to put a petrol station with above ground storage of fuel right next to a daycare centre or a residential activity or even a retirement village or something to that effect. There are risks, particularly when we're talking about above ground storage tanks, so something to consider there. The second one is the risk of natural hazard issues. So looking at, you know, by using hazardous substances, are we posing a risk if there is a natural hazard issue or event? So the key one there, which I've been in discussions with Ian about, who will present later on the natural hazards topic, is, you know, storage of hazardous substances in flood risk areas and what that might look like in terms of if a disaster or event occurred, how would that be managed? And then the third one is, you know, consultation with other land use activities in the area. So if we don't have anything in the district plan around hazardous substances. This is a risk for the people that live in those environments to not have a say, to not know if there's going to be, for instance, from my experiences at Waikato, we had a what was it, Norbert? It was a fireworks manufacturing, like explosives manufacturing company, which, you know, next to a residential environment, and for good reason. The application was publicly notified to give everybody an opportunity to know that they were actually within a risk area. That could mean that if the worst case scenario event occurred and the place exploded, that they were in a high risk area where it could cause damage to property and to people's lives. So those are the types of things we're talking about with consultation, is, you know, what's the risk look like to those people. Cumulative risks is also a really key one when we're talking about multiple hazardous facilities all within proximity of each other. So if you think about an industrial zone, we might have storage of fertilizers in one site and fuel at another, and cumulatively, application by application, we might have, you know, a recipe for disaster if that's not managed in the district plan. So cumulative risks is about looking at the surrounding environment and deciding, you know, is it okay to put another fuel station here when we've already got 3, for example. And a good example of that actually is down in Pukekohe. You'll know there's like 3 petrol stations all within proximity of each other, either side of the motorway. So if one exploded, more than likely there's probably some risks around those as other sites from potential impact as well. So just things like that to consider as part of applications. And then the 5th one is a rigorous and systematic risk assessment process. So without any provisions in the district plan requiring applicants to provide a risk assessment of a hazardous facility, there would be, you know, no way that we would know is the Dargaville Township at risk of an application on the outskirts where it could lead to, you know, explosions, or depending on what types of hazardous substances they've got going on there. So what I've provided in the handout to you is obviously the objectives and the policies, which I've put in this slide here as well. But I guess today what we're really wanting to get into the detail of, and sorry, the proposed rules are there as well. Your Worship, I'm not sure if you want me to go through the proposed rules in any detail. I've got Norbert here today if you do have questions around those, but if I can leap forward to the direction we're seeking, I think that would be a good discussion.
Just before you move on, I'm keen for us to get to the direction that you need from us, all right? But just before you move to that, just going, if you go back a slide, please, Catherine.
To the objectives and policies, Your Worship?
Correct.
Yep.
One further back as well.
Oh, certainly. Yep.
To your list of the 5. This is 5 things. Yeah. So the second point there, just on regarding local natural hazard issues, and when we're talking, and we'll be talking about this later, regarding natural hazards and climate change and sea level rise, what horizon are you talking to here regarding, are you talking about the 1 in 10 year flood or the 1 in 100 year? When you're talking about the following gaps need to be taken into account, local natural hazard issues, what lens is that going to be? Is that going to be a really highly sensitive risk lens, or is that a longer lens for what we're talking about here? Because that's not specified in that point number 2.
No, Your Worship, and to be quite honest, at this stage we haven't got to the point of deciding what those rules will look like. So Ian and I have had a discussion, and we obviously haven't formulated rules for the natural hazards chapter as of yet, but I would assume that it's more the high risk events that we're probably most interested in, but I won't rule out the lower scale events as well, because we haven't assessed what that might look like. So the perfect answer here is really we haven't got there yet, Your Worship, but it's something that we will certainly be looking at.
Thank you. I'm mindful of that example from down south in the Southland, and I'm going to say, is it in Gore where they have an old factory that's right beside the river, which is now a massive contaminated site, and it's a major issue for the council to have to deal with. And so it's kind of trying to be ahead of the story, if you like, in this case, on those sorts of issues. Thank you. Is that Norbert wanting to join?
Yes, that is me. If I could barge in there, just in terms of the examples, I think what you're referring to is the storage of dross from the TOI smelter site, which is actually in various sites all over Southland. It is not just the one site. That old paper factory actually has been emptied now. So the material has been moved to other sites. But the problem persists certainly for those other sites. And sometimes due to a lack of controls, material has been deposited on sites that didn't require any consent. The same issue applied with Timaru, the big cleanup of an electroplating site, which costs millions. And the problem is the costs are usually borne by taxpayers and ratepayers, not by the polluters. Closer to home, you have the example of the Ruakaka solvent site, and I'm not sure how familiar you are with it, but some of you probably are, just across in Whangarei, which cost ratepayers and taxpayers already about 3 million just to remove the material from the site. And that includes Kaipara ratepayers through the regional council, because that was involved in the cleanup. So to avoid these sort of major issues, that is the reason for choosing to put something in the plan.
Thank you very much for that, Norbert. Nice to see you, and thank you for that contribution and for filling in the gaps in my hazy knowledge of what's happening at the other end of the country. But just certainly regarding that, our flood hazard issues, it's certainly a lens that we're across here. But thank you for that. Catherine, back to you, and we'll carry on, please, and seeking towards your direction that you're seeking from us. Thank you.
Certainly, Your Worship. Okay, so I've just got two kind of major questions here for elected members today, which is, so I've explained that Council has no explicit function under Section 31 of the Resource Management Act. But the question that we need to decide is, do elected members want to control hazardous substances in the proposed district plan? And if yes, do we consider that staff are on the right track with the types of activities proposed to be controlled within the Kaipara district? So that relates back to the provisions that I've provided you as a draft. So Norbert has reviewed those draft provisions, and we've got a few little tweaks to make. There's a few updates that need to be incorporated into there, but they're not substantial that it's going to matter for today's discussion. So I'm going to pass back to you, Your Worship, just to provide some direction on this matter. Okay. And if you need anything technical, we're both here.
All right, thank you. So what we'll do, elected members, we'll take these two questions one at a time. So we'll just deal with the first one first, and then we'll come all round again, okay, for the second one as well. My perspective here is certainly in the world that we're headed into, I think it would be right that we are looking at hazardous substances in our district plan rather than being silent in the space. I think into the future, I think that's responsible for us to be in that space and in the direction that, yeah, we'll come back to the direction in a moment, but of where it's headed, but certainly in that first principled approach, yeah. That would be my thought. So open to other elected members. So if you could put your hands up, or I can just go to everyone if you want. Councillor Curnow, hand up.
Yes, I agree that I think we should have some provisions around controlling hazardous substances. And just in the draft proposed rules that you've put in, I just wondered whether, and this may be overreach, but whether there's something about the level of expertise around the staff that are involved in the storage and the cleanup and all the rest of that, just because I believe certainly the issue that we've had up in Ruakaka, there was a level of, part of that was the lack of expertise and the just simply not knowing what they were doing that contributed to that problem, and then walking away and leaving it. So I don't know whether that's overreach, but yeah, that was just something that came up when I was reading the draft provision. Yeah.
Thank you. Thank you. Further commentary from elected members, please.
Oh,
Councillor Weddy, and then Councillor Delavaris Woodcock. Thank you.
Yeah. Thank you, Mr. Mayor. I guess my concern here is that I think it should be included, but I don't think it should be just an overlay on an overlay. If there are already provisions that are in the regional plan or the national standards, etc., then our district plan should refer these things, hazardous substances, etc., to those provisions, and make sure that whoever's applying for them under our district plan complies with the regional standards. I don't think we should have our own set that people have. I think this is the point that Councillor Vincent was raising. We don't want an individual applicant having to go and basically get the same sign off from about 2 or 3 different territorial authorities. So I'm very conscious that this is just a level of bureaucracy that we see creeping in. If there's something specific to Kaipara that's different from everywhere else, then that should be clearly specified in detail. But if it's a general statement, then we should be just fitting in with the already established regional requirements. So that's my comment. Thank you.
Thank you, Councillor Delavaris Woodcock, then Councillor Larson.
Thank you, Mr. Mayor. I think that development, it seems to be that developers go to our district plan first, rather than to the regional policy statement or regional plan. And I think how unequivocally our district plan needs to give clear instructions and rules about appropriate use and development to protect Kaipara's environment and our well-being. And so I fully support the staff's proposed policies, hazardous substances policies 1 to 4 that are there in the material for this briefing.
Thank you. Thank you, Councillor Larson.
Thank you, Mr. Mayor. Yeah, I don't want to duplicate roles that other entities are already undertaking with this, and I'd like some clarity around that in terms of the regional council function and the FENS function. Like, I'm hearing people talking about cleanup and stuff. Well, I certainly wouldn't want our council getting involved in any of that. Officers appointed under the HASNO Act ought to be doing that, and I don't think we should wade into that if we don't have to. Enough other things to do as it is. So I just wonder whether we can actually, rather than trying to rewrite things, incorporate by reference another document and have that noted in the plan so that it is comprehensive rather than picking pieces from somewhere else. And maybe we can just incorporate by reference a regional document or a national document rather than trying to do a piecemeal approach ourselves. Thank you.
Thank you, Councillor Wills, and then Councillor Vincent.
Thanks, Mr. Mayor. Good morning. I read through this and I tend to agree that we need to avoid duplicating the regional council rules. The concern I've got is that my understanding of the Ruakaka incident, that both the Whangarei Council and the regional council tried to enforce the cleanup process, but it became very quickly apparent that the Whangarei Council did not have the resources to do so and had ended up having to defer to the regional council. That would be the same for us if a similar situation happened. So if we can't enforce it or finance the fixing of it, it's hard to justify having the rules in place to start with.
Okay, thank you, Councillor Vincent. And Councillor Vincent, you've got a very, very grainy image there. You may want to turn off your camera so to ensure that we can hear you.
Thank you, Mr. Mayor. I guess one of these, a comment I could make in response is that this will all be resolved in terms of this interagency problem with the RMA reforms, because that will all be part of one plan. So we've got that to look forward to. So we don't need to angst too much about it, I think, because in the foreseeable future that will be resolved. The other thing, my other comment is that I guess Norbert's comments certainly influenced me in terms of we do need to see to the welfare of our citizens, but also whatever course of action minimises our exposure to cost in terms of being responsible for cleanup is what appeals to me. Thank you.
Okay. Thank you. So,
Mr. Mayor, can I ask the staff a question?
Councillor De Lavaris Woodcock, question for clarification. Yep.
Yes, thank you, Mayor. Staff, could you please answer this question? Is the intent of having these rules regarding hazardous substances to avoid the result of contaminated land? So everybody's spoken to us not having to deal with the cost of contamination of land in the future, but are we not putting the rules in place to avoid such a problem occurring?
Through you, Your Worship, if I can respond to that, and Norbert might want to chip in here, but I think the simple thing it comes back to, Councillor, is that it's not just about preventing the ambulance at the bottom of the cliff, which is the contaminated land. It's also about making sure that we're giving our Kaipara residents an opportunity to participate in a process of land use planning. So remember that these other authorities, so Regional Council have their jurisdictional functions for hazardous substances. The Hazard Authority does not play a role in land use planning at all, and neither does Health and Safety, WorkSafe New Zealand, I should say. So the one that's left behind is Kaipara District Council, and we need to decide if we don't have any provisions in the plan, are we okay to let it be a permitted activity and just accept the risk that comes with that? And I guess another important point, which I probably didn't make before, is that these rules are developed to ensure we're talking about the bigger quantities of hazardous substances. So the activities threshold table that Norbert has helped me with, which is reliant on how much of a substance or class of substance is appropriate, is really directed at major hazardous facilities or bigger activities. So we're not looking at the farmers who store a bit of fertilizer, or me with my lawnmower, I store a bit of fuel, to run around and do that on the weekend. But it's not about that. It's about the bigger scale activities that we need to look at to make sure we are preventing any risk to those communities. And like I said before, sensitive environments in particular, as well as cumulative risk, which you cannot do without having any provisions in the district plan. And then simply it becomes a case of we accept the risk that comes with that if we're going to permit those activities. So Norbert, did you have anything in addition to that? Hopefully that helps answer Councillor De Lavaris Woodcock's question.
Yeah, I just have some generic comments on the various issues raised and questions. I absolutely agree. These provisions, the intent of the provisions is avoid coming to a situation where you have to deal with a major issue, a major cleanup, And it is not about whether the district council has the expertise in-house to deal with a major cleanup. That is not the point. It is to avoid coming into that situation in the first place. Once you have a contaminated site, you usually deal with discharge issues, and then relatively clearly you have a regional council that deals with that. That is not your issue. However, as far as the land use side of the legislation is concerned, it is the district council. That is very clear. There is no question about it. There is no duplication. The provisions have been developed in a way that they are consistent, both with the national planning standard and the regional direction, both in terms of the policy statement and the existing regional plan, but also in terms of the proposed regional plan, which does not have any rules for hazardous substance land use issues whatsoever. So there is no duplication. And the final point, yes, the RMA reforms will come and it will affect plans in about 10 years' time, but it is about between now and 10 years that we're looking at. And the provisions are written in a way that you don't target particular industries, particular activities. You may get a hydrogen storage facility proposed for the district. With these provisions, you could deal with that. If you don't have anything in there, tough, you can't control it. So the point really is to be open for major changes that could occur. The provisions are largely aligned with what you used to have. So we're really looking at 2, 3, 5 applications in a 10-year period. So the extreme cases, rather than day-to-day activities, they are clearly exempt.
Thank you. That's crystal clear. Thank you, Norbert, for that extra information. Thank you, Catherine, for that extra information as well. I'm actually going to go round again because I just think that the questions that we've heard and the positions and the direction that the elected members asked the first time around here kind of has actually been resolved by what Norbert has just said. This is not about small farmers. This is not about this is about large, potentially large things, and actually the principled approach and the fact that there is no duplication with the other agencies. So now that everyone's got that absolutely clear, let's go around again. So my position on this is we're still on the first question here. I believe that council should control hazardous substances in the proposed district plan, just as a principled approach. So we're going to go around again. Thank you. I'd say, Councillor, based on the written comments, Councillor De Lavaris Woodcock would be saying the same. I'm just after a yes, no kind of situation.
Yes, concur with what the Mayor has just said.
Thank you. So we just, this is really straightforward here. We're just going for simple direction. So we're just going to go around the screen. Councillor Vincent.
Yes.
Thank you. Councillor Wills. No direction. Okay. Councillor Curnow.
Yes, my view hasn't changed.
Okay. Thank you. Councillor Larson.
If it's going in, keep it as simple as possible. Thank you.
Lovely. Thank you. Councillor Withy.
Yes, on the condition that it is clearly referenced what's already in place from the regional plan point of view, and this is an additional requirement. So there's absolutely no duplication at all.
Okay, great. Look, that's really clear direction. Thank you. I think, Catherine, I think that you've got clear direction there on that first question. If we can go now to your second question that you've asked us, that if there's a yes, which is, I'm going based on what you've just seen, that there's a yes, do you consider staff are on the right track with the types of activities proposed to be controlled within Kaipara District? So this is page 13 of the page just prior, where there's a list for those proposed kind of rules and so on, and what may be going on here. So certainly, Norbert, thank you for the commentary you just made as well, because that regarding hydrogen energy and so on, because that also helps within the space that this work fits in, and if you like, excluding the small scale individual farmers, if you like, who are covered by other kind of on farm plan kind of work. And so I have a question for the officers here regarding the control of radioactive material. Like, would this potentially affect the hospital, the vet clinics, so on, which are doing x-rays and so on, and or any other facilities such as that, or are they kind of safely outside the net of the control of radioactive material lens that you've got here? Could I have some clarity on that, please?
Certainly, Your Worship. I might get Norbert to respond to that. I'm just looking up the rule at the moment. What have we said?
I can just say that in principle, this. Can you hear me?
Yep.
Yep.
Good. I didn't come up as blue. In principle, the provisions as provided for in the draft are based on what you used to have. That means anything standard that includes equipment is exempt anyway through the radiation protection regulations. It is about hazardous substances, not about equipment. So it is really something major and very unlikely, and as such, to a degree, probably only symbolic. It came up in the early 90s when it was proposed, for example, to have irradiation plants for food processing established in New Zealand. That did not happen at the time. It does happen in Australia. If something like that would be proposed for a major food processing facility, it may trigger it, but it is very unlikely and, as I said, more symbolic than relevant in day-to-day activities.
Again, very clear. Thank you, Norbert. Councillor Curnow.
Yes, I think we're on the right direction. I just had a question around proposed policy 2, the assessment of risk of hazardous substances. Are we sure that that isn't covered elsewhere? Just in the in the line with what the previous comments have been around duplication.
Yeah, can I just say that is one of these many misunderstandings about other legislation. The assessment in terms of effect outside of the factory, if I use that term, or the hazardous facility, is not something that the workplace legislation as such picks up. The purpose of that is the protection of people, particularly workers within the workplace. So it is not outside. It also does not have the environmental aspect, so the protection of the natural environment, ecosystem, biodiversity, all these sort of things included. So it does not have that type of assessment, nor has no initial approval process, which is really about new substances being approved. It is not about existing substances. So it is about whether a new substance should actually come into New Zealand or should be manufactured in New Zealand. That's the primary purpose of HESNO nowadays. And what they're dealing with is really 80% new pesticides. That is the primary focus. It is not about all the stuff that is here and the effects that it has in a particular location. So the locational issues is entirely resource management.
And so is this proposed policy, I'm just thinking in terms of if I was wanting to set up a factory that stored hydrogen or something like that. So is it my responsibility to look at the cumulative effects? And by cumulative effects, do we mean what everyone else is doing around me as well? Or is it, so I'm just not entirely clear what that policy is about in terms of, is it the applicant's responsibility to assess that, or is it council's responsibility to assess that? And how does that work?
It is basically the applicant's responsibility to assess all the relevant risks in the land use context, and that could include cumulative effects. It is really an obvious case where you have an explosives factory next to something that stores fuel. You wouldn't want to have them next door. It makes sense. Most people in their right mind would not propose it. But there is the odd occasion where it has come up. There is the odd occasion where you have existing zoning provisions that permitted over time some activity somewhere that is somewhat questionable, but now you have a rezoning next door that allows something else. And at some point, suddenly you get an interaction between the two.
Yeah.
That is really the point. Again, it is a rare point, but it gives you the opportunity to look at that. My final point is that is an assessment matter. It is really for council to look at and say, we need more scrutiny on this. It is not about prohibiting anything.
Yeah.
There is no provision proposed that prohibits any activity.
Okay. So it's a responsibility on the applicant to do an assessment, and then for council to check that that assessment is extensive and appropriate.
Correct.
Okay. Cool. Thank you. So
Thank you, Councillor Curnow. Yeah, yep.
So sorry, I've lost my thread here. Are we just asking questions now, or are we making a statement about the?
Sorry, if no one has any further questions for clarification here, Councillor Withy has, then I'd like to move it right. So we're still in questions. Thank you, Councillor Withy. Question for clarification. This is on that kind of second point that Catherine's got.
Yeah, what I'm seeking, and this is in the proposed rules, and you've got some limits here in terms of the different zones that are in question. And in the residential rural lifestyle settlement zone, what I'm really asking is, are these thresholds that you've listed here, how do we compare? Where do we get those from? Because I'm just looking at some of them, you know, down the line in terms of the corrosive liquids and highly oxidizing substances. There's some quite reasonable quantities there for some of these zones. So my question is, where did we get advice, or are we in line with other territorial authorities? Just where do those figures come from?
I can probably answer that, Catherine.
Yep, go for it, Norbert.
Yeah, to a large degree, the thresholds proposed are what you have in the operative plan. So it is basically based on the principle not to reinvent the wheel, to have as much as possible adopted again that you had in the plan where it didn't generate any problems. The provisions align with all those councils that have a similar methodology to determine the activity status. And there is about a dozen or so local authorities in the country that do that, including the Auckland Council. So you are aligned there with very similar numbers. Far North and Whangarei have a slightly different approach with a historical method, the hazardous facilities screening procedure, which is more complex, and which I think the Kaipara District Council, the last time 12, 14 years ago, I don't know when it was, the plan provisions were reviewed, rejected because it is too complex. And Far North, at least at this point, is moving away from them as well. So overall, yes, those numbers align with what many, if not most, local authorities are doing. And the two systems are actually linked because your threshold table system is based on the principles of the methodology that Far North and Whangarei have. So yes, the numbers are generally aligned.
Okay, thank you for that, Norbert. Thank you.
Thank you, Councillor Wills. Thank you.
Thanks. Yeah, I did. I put my hand up and took it down and put it back up. Because the questions were getting answered as we went. My concern is keeping it up at that significant hazardous level. But my question is, I personally would consider all of our rubbish sites significant hazardous facilities. Are we going to put a noose around our own neck as far as our ability to make decisions on our own disposal as a council of our community waste?
Norbert, I'm going to ask you the question in terms of landfill sites and your experience around those, because we haven't actually touched on that, Councillor Wills.
As such, the provisions here are for the use and manufacturing and storage of hazardous substances, which are defined through their hazards. In terms of hazardous waste, you often have a mixture of things that have various hazards, but that are not necessarily clearly determined in terms of what they are. And sometimes they're quite difficult, and sometimes they can change as well if you add water or air or something else. So hazardous waste as such is not included in these provisions. It is about the disposal of hazardous substances insofar as they're identified individual substances, but where you deal with existing waste disposal, landfill sites, these provisions are not proposed to address that.
Yeah.
But how can they avoid it if we're going to apply a blanket rule across the district? I mean, because some of the sites include the delivery of hazardous substances from farms and that. How can that be contrary to our own operation?
Now, again, as we indicated, the quantities that you're dealing with in farms generally would not trigger a consent when they are on the farm. Hence, they would not trigger a consent when they are delivered to a site. However, how that waste site is set up, there are landfill guidelines, how that waste site is set up to accept or not to accept hazardous waste, and how it is tested is something that a waste management provision should address. It is not addressed in these provisions.
Yeah, I was just going to add there that Councillor Wills, I'm pretty sure most of our landfills would not dispose of hazardous waste. They have to be consented for that. There's not many facilities around the country that do accept hazardous waste in their landfills, but I can tell you that there are a lot of the historic ones have already been identified as hail sites across the district, so they're already on the regional council maps because who knows what's in those. But any new facilities that are established would have to go through quite a rigorous consent with the regional council and Kaipara District Council to work through what they could dispose of, and that comes down to whether they're lined or not lined, those types of things. So I think Norbert's quite right. It's around hazardous waste management, which actually does fall under a land use category that you'll see in the rural zone provisions and across the plan in various forms, depending on whether we want it to be more permissive or not, if that's helpful.
Can I just add that one major waste facility that you're probably all familiar with is not existing yet, the proposed Stone Valley landfill. That is not set up to accept hazardous waste in any quantities. That is not an issue there. So I would say that for any new facility, if even a landfill of that size is not set up to deal with it, you basically should not have anything new that accepts hazardous waste in your district in any large quantities.
Thank you.
Oh, thank you. Just when things were going well, Norbert, then you raised the Dome Valley landfill discussion, but let's not even go there. Thank you. No to that. Thanks for that. What we need is direction for Catherine. So I'm not sure if elected members have sufficient information to be providing the direction now based on the presentation that we've had, but I'm not seeing resistance to that now. So I'm clear about the scale of what we're talking about here, that it's not, again, at a single dwelling or single small farm or at that highly localized level. It's about hazardous substances at scale. So and so that is a very clear proposition for us. So I, again, notwithstanding that this lines up with consistently with other the other regulatory authorities here, I'm happy for us to be headed in the direction of what is proposed here with these rules by the officers of the staff with the expert professional advice. Remembering that this goes out for discussion and consultation. We've still got a long way to go here, but nevertheless, the Kaipara District Council is taking a principled approach. That's what I would say in this space. Thank you, and I'm open for further direction from elected members here. This is on the second of Catherine's points, so you may want to pull that up, Catherine. So we'll go with Deputy Mayor Curnow.
Yes, I'm.
Oh, tech. Sorry, could you repeat that, please? Just your sound cut.
Sorry, I thought I'd unmuted, but I clearly hadn't. Yes, I'm happy with the overall direction, that we're on the right track in terms of the types of activities and the absence of overlap with other regulations.
Thank you. Thank you. So I'm looking for, we've got a written comment from Councillor De Lavaris Woodcock in the chat box that she's satisfied with this direction as well. Seeking further direction from elected members here with hands. Yep. Thank you. Is that Councillor Wethy? Yep. Thank you.
Yeah, I think on the basis that we've had the descriptions from staff, etc., I'm happy with that direction to keep proceeding the way it's going. Thank you. Yeah.
Thank you. Thank you. Further commentary, Councillor Larson, Councillor Vincent, Councillor Wills. We seem to have a IT glitch right now. Councillor Vincent, can you hear me?
Thank you, Mr. Mayor. I did put out a couple of thumbs ups on my screen. I'm hoping you'll see that.
They didn't come through on ours. Sorry.
Okay.
Stop sharing.
Sorry. Yep. So I'm okay. Yeah, I didn't want to waste anyone's time unnecessarily.
So you're happy with that direction?
Yes.
Okay.
Yeah, in the line of conversation that has gone on. I've also previously made comments on but no, that's relating to hazardous substances. So we'll get to that in due course.
Great, thank you. Councillors Larson, Councillor Wills appears to have dropped out of the meeting. IT issues. Councillor Larson, I don't know if you'd like to provide any direction here.
Oh, I don't need to say anything more at this stage. We'll come back to it once we've got another draft. Thank you.
Okay, thank you. All right, so Catherine, I think that brings us to the end of this piece. I think we've provided clear direction for you. Yes, can I have a thumbs up from Michael Day if that's sufficiently clear direction?
Yeah.
Yes, thank you, Your Worship. That is great direction from the team.
Okay. Look, thank you. So, and Norbert, thank you for your expert contributions there with us today as well. Thank you for your work with the team. So, Catherine, back to you. Thank you. Kia ora.
Oh. Sorry, Your Worship. This technical glitch with my finger. Right, next slide. Where are we at? I think this moves us on to
That's
the
the end of
presentation.
your presentation,
Yeah.
Catherine.
Yep.
Your Worship, would you like us to go straight into hazards, or would you like a quick break?
I think we should have our break now, as originally planned. So we'll keep the meeting moving along. So we'll take a break now. So we will resume. So 10-minute break, everybody, and we'll resume at 10:45 a.m. with natural hazards and climate change as our next piece of our district plan review briefing. Thank you. 10 minutes from now. Kia ora. Right, 10:45. So that was a very quick little 10-minute break. Hope you all refreshed and watered on this very warm day. So Michael, back to you for our next section of today, which is natural hazards and climate change.
Thank you, Your Worship. I'm going to hand over to Ian Mayhew from Foresight Consulting, who will step you through the next presentation and seek direction. Staff will be chipping in as well, including our GIS expert, Kyle Middleton, when needed.
Thank you.
Thank you. Over to you, Ian.
Morena, kia ora koutou. My name's Ian Mayhew. I'm a policy and planning consultant with Foresight Consulting. We'll just kick off. Catherine, if I'm just going to have to do the slides remotely through Catherine, so just excuse that. A number of the slides are just for background purposes, so I won't go through everything that we've prepared here in detail, but it's good just to perhaps open up with this slide around natural hazards. Now, as you're aware, they are events that are outside of control, although human activities, of course, can exacerbate them. But really what we're seeking to control through district planning rules is the way land is used and subdivided and developed, which of course can increase risk, both to people, properties and buildings and infrastructure. One thing I'd just like to, and it came up a little bit before, is just that not all the hazards are the same, and some are, for example, coastal hazards are hazards that are likely to occur over a long time frame and become more apparent and more severe over time. Others, of course, such as flooding, as the Northland experienced last year, can occur at any time. And so there's not a single response to managing natural hazards because of the nature of the hazards and the effects that they can give rise to, and they can't be avoided, but risks and consequences can be managed. Catherine, if you could just go to the next slide. I put some slides in here around the statutory framework. I'm sure that you are familiar with that, so I don't propose to really cover those in any detail. If you've got questions, please ask when we get through to that. It may be that when we have a discussion at the end, we do come back to look at what the overarching statutory provisions are directing councils to do. In this case, the most appropriate or the most significant, of course, is the NZCPS and the Northland Regional Policy Statement. And as I've said in that slide, you know, some plans are, some provisions are quite directive, which means that council needs to adopt them as it must give effect to them. Others are more guiding or providing sort of information on things. So, Catherine, I suggest we just sort of skip through the slides that have that background. As I say, I think councillors, with your agreement, we'll come back to those if we need to. Now, the operative plan covers 5 main types of hazards: river flooding, land instability, coastal erosion and sea level rise, coastal inundation and wildfire. That's a pretty typical set of hazards that are managed by district plans. Other ones that are included in some plans include tsunami risk, so they do manage development in relation to tsunamis, and also seismic risk in some areas. Northland is relatively low in terms of its seismic risk, but liquefaction and things can be an issue in some areas, but that would generally fit under land instability. So it's pretty typical package. And those provisions and rules are primarily implemented through subdivision and land use. And again, that's a relatively common approach. So just the next one. So Northland has, as you are, I'm sure, aware, a Northland Regional Council has mapped a number of hazards, and they have been updated this year, particularly the river flooding and coastal coastal hazards. So currently there's maps for river flooding, 10, 50 and 100 year ARI. So I'm sure you're familiar with that terminology, but those are events that on average occur every 10 years, every 50 years and every 100 years. But of course, any of that scale event could happen at any time. Coastal flooding, so there are a number of zones, the current zone, zone 1, 2 and 3, which are associated with different climate change scenarios and sea level rise, and the timeframes over what that will occur. You would have noticed from the slides on the NZCPS that the NZCPS directs to manage coastal hazards to the 100-year future scenarios. Northland has mapped some coastal erosion, but that has been done around particular areas in Northland. So it's selected sites only. It's not a district-wide map. And in Kaipara, there are 4 areas that have been where coastal erosion has been assessed and mapped. They're listed there. And again, there are a number of there are 4 zones, a current zone, and the same erosion risk associated with those 3 different future sea level rise scenarios. The Kaipara district itself has mapped 80 selected areas of land instability associated with high and medium risk. So we're at a very early stage in terms of developing provisions and really managing hazards is sort of, there's a spectrum of risk and there's a spectrum of control, and really I guess today I was trying to get a bit of a steer for where the council would like to land on that. Is it more controlling? Is it more enabling? Where does it see these risks? It's not a one size fits all. It's very much a matrix type of approach, different hazards, different land use activities. And really what just talking about here is that risk does depend on land use. And the vulnerability, in particular the vulnerability to that hazard, and you'll see in the later slides I refer to vulnerability and vulnerable activities, because some are more sensitive to certain hazards. The risks are higher, potentially the costs are higher, and certainly for some hazards, the social and community costs are higher. So typically when we talk about vulnerability, it's primarily used in the urban sense. Here we are talking about those higher, more vulnerable activities being those that are residential type activities, care type facilities, so retirement villages, and other areas, hospitals, care, often marae as well, and things like that. So just on the next slide, Catherine, please. It's really important, I think, to have a context around hazards and the extent to which they may impact the district. It's really important that the presence of a hazard doesn't necessarily mean it constitutes a risk, but it is one indicator, of course, of that. So we've just done some initial work on the extent of the major zones. We've actually done that for all zones, but only presented the 4 main zones here around land that is within the mapped hazards areas. And so this is the area of land. The next slide, which we won't go into quite yet, is the number of buildings. So we've been able to actually have a look at that just to get an idea of that. And I think the key thing from my perspective on this is if we're looking particularly at the flood and coastal hazard zone, flood hazard zones, particular is around the business land within those zones. So a relatively high proportion of that, not surprisingly, as we'll see in slides relating to Dargaville, other areas, and also a proportion of residential as would be expected in flood hazard zones. If we just turn to the number of buildings, Catherine. So a similar picture. So there is a reasonable amount of existing development within the flood hazard zones, and we'll talk about that. And that's obviously one of the areas we wanted to discuss is that Often land use and subdivision rules are focused on new development, but where we'd also like to get a steer is on the potential for redevelopment or extension to this development, and how the council might see the plan working in that regard. Just to show a tangible example of it, we can just go to the next slide. Oh, sorry, just on the hazard notes, of course. When we're looking at those numbers, a number of those are, of course, concentric mapping. So if a site is in the 10-year flood zone, it will also be in the 100-year zone. So you shouldn't add up the numbers to get the cumulative number of buildings. The same for the coastal hazards and things like that. So it's, of course, if you're in a flood zone and you're in the 10-year, the chances are that the depth of that flood will be higher.
Haven't you got that back to front?
As we've seen and we've talked about, commercial industrial, often located in floodplains. That's not unique to Kaipara District, of course. That's pretty much the case everywhere.
I think your
Certainly,
statement, all the land in a 10-year flood zone is also in a 100-year flood zone. Wouldn't you put it around the other way? All the land in the 100-year flood zone is also in the 10-year flood zone.
No, because you might be on the edge of the 100-year and be outside of the 10-year. So 100-year is a less frequent event, and so it encompasses a much bigger area. But we can show that. We'll show that on the mapping in a second. We've got some maps, and we'll
I'll leave you to it. Sorry, carry on.
Thank you, Ian. Thank you. Please proceed, Ian. Thank you.
Thank you. And as I touched on, the coastal erosion and land instability are mapped in specific areas, so they're not a district-wide layer. And so numbers are relatively low. They may be higher if it was to be a more larger scale assessment. So if we just turn to an example of this, and I'll ask, this is a static map, but we've got Kyle there with the GIS, which can show you how these layers build up. But a number of sites, of course, are subject to multiple hazards, particularly those that are near rivers and near the coastal marine area. But Kyle, maybe if you could just very quickly show that same
I'll take over the screen.
And then you can turn some of the overlays on and off.
Can everybody see the screen?
Yes.
Okay, so for example, if we want to look at Dargaville Township, the coastal flood hazard zones that were mentioned earlier, river flood hazard zones that were mentioned, we have the 1 in 100 and 1 in 10-year event. The 1 in 10-year event in the lighter blue, as it's a more frequent flood event, it has a smaller extent. So I could turn off the 100. That lighter blue shows you where it's been modelled as a 1 in 10-year flood event. The 1 in 100-year flood event is obviously that and then some. So it includes additional land. So there'll be plenty of buildings that intersect and properties and areas of the zones that intersect the 1 in 100-year flood event, but not the 1 in 10. The same thing goes for coastal flood hazard zones. Here we have 4, 0, 1, 2, and 3, so 4 event models, and they increase in extent at each stage. Would you like me to, Ian, would you like me to discuss the geotechnical risk hazards and the coastal erosion hazard zones, or we're just giving you?
I think if we just went to Mangawhai and just showed an example of the coastal hazard zones, the coastal erosion zones.
So the coastal erosion zones, as we discussed, weren't mapped for the entire district, but Mangawhai is an area where they were mapped. And for the purposes generally and through NRC's illustrations of these, they're illustrated as lines, as boundaries as to where the exposure occurs. But for the purposes that I was doing, where I was doing exposure counts on buildings, I needed to refer to these as polygons. So I generated these polygons. So say the darker maroon here, this is coastal erosion hazard zone 2. So this building would be considered impacted by that coastal erosion. whereas not impacted by coastal erosion hazard zone 1.
Okay, is there any, just while we've got Kyle on there, is there any questions from the councillors just around that, or anything they'd just like to see while we've got the GIS up? Otherwise, I'll continue.
Yeah.
Councillor Wethy.
Could you get Kyle to just scroll down to the Lincoln Street area, which is probably more prone to surface flooding from the
I'm not
coast?
familiar with where Lincoln Street is. I'm sorry.
Well, if you go south from where you were at Alamar Crescent, just keep on going down, tracking down the coast. Okay, just a bit
Lincoln
further.
Street here. Yep.
There we are. Yeah, where are you?
It's Lincoln Street. Yes, well done.
Yeah, just go up a little bit further.
Wethy, you're beaming at us right now from there. Yes.
No, you've gone. No, you need to go up a little bit. Move, scroll. I need to look a bit further. Stop. There we are. Now, put your overlays on that now.
Would you like to look at the coastal flood hazard or
Yes,
the coastal erosion?
Oh well, you could have a look at both of them, but
okay. Well, here's your coastal erosion hazard zones as they've been mapped by NRC.
Yeah, you'll see all of those houses around that bend there. So many of them are impacted when you start looking at that. Yeah,
they would be impacted, and then I presume even more so by the coastal flood hazard zones. These houses are inside all 4 flood events. These particular houses.
Although Alamar Crescent is often zeroed in on, I believe that this is more vulnerable, and you've got some very high real estate around here. Yeah.
Okay, and look, I mean, I think that's an important example, because with the hazard provisions, we're kind of managing future subdivision and development, but at the same time, there are a number of properties, residential and of course commercial and industrial, that are within hazard zones. So the provisions need to provide and manage future development, but also consider current development, and that's obviously one of the areas we're keen to get a steer on. So Catherine, I think, thank you, Kyle. I think if we could just go back to the presentation where we just talk about that general approach.
Excuse me, Mr. Mayor, may I ask Ian a question, and Kyle?
Councillor Delavaris Woodcock, question for Ian. Mayhew, thanks.
Yes, so for clarification, coastal flooding, Ian, occurs, I know that there's sea level rise, but could you describe or define the coastal flooding? Is it like an event caused by high tides intersecting with a deluge of rain? Or is coastal flooding erosion to do with sea level rise only, so incremental over the next 100 ongoing years?
Just an answer to that, it's a bit of both. Not so much the river flooding itself, but it is normally you have sea level rise over a period of time, and then you provide for wave run up. So in a storm, of course, sea level can actually increase above what it would be in a sort of an ambient condition. And so modelling normally accounts for, well, the Northland modelling accounts for both sea level rise, but also wave run up. I don't think it incorporates a combination of river flooding and sea level rise and wave run up, but I would need to check that. I think they're done independently and then overlaid, but I can check that for you. I'm sorry, I don't know that. But certainly wave run up is taken into account in the coastal inundation.
Thank you.
Thank you.
Sorry, if I can just add to that, of the 3 with regards to the coastal flood hazard zones, and we can see them illustrated in the various shades of turquoise in the still image we have on our screen. Only zone 3 also includes the sea level rise scenario. So where it has coastal flood hazard zone 2, that is your 1 in 100 year flood event. So there is essentially a It's 1% AEP. It's a flood event under certain conditions, and it's expected to happen. We have a 1 in 100 chance each year. And then Coastal Flood Hazard Zone 3 is presuming that same level and that same ferocity of flood event with expected sea level rise on top, just to illustrate how much more of an impact it would have.
Okay, we might just need to confirm that.
Yeah, that's not
my understanding.
Sorry,
but
that's not technically correct.
Yeah.
Sorry.
It's not correct. So the Coastal Flood Hazard Zone 1 and 2 incorporate an allowance for sea level rise in those models already.
Okay, thank you. Kyle, we have a request here from Councillor Vincent for a look at Mangawhai Central. If you could use your GIS tool to go back to the Mangawhai Central area regarding both the flood hazard mapping and the sea level rise mapping. Yeah.
Yep. I will. So Mangawhai Central up in here.
Correct.
Sorry, I'll just wait for my computer to catch up.
These are wonderful tools. Look at and
coastal. I'll switch to the aerial imagery. Hopefully that'll give us a little bit better understanding of where we are. The coastal flood hazard zones. Look up and land around the edges of the estuary.
Yeah.
The coastal, I don't think river flood has been modelled here, nor coastal erosion. Let's just have a quick look. River flood has, where you have your 1 in 10 and 1 in 100. And then the coastal erosion hasn't been modelled on this side of the Mangawhai Harbour.
Okay, so if you were just to lay that all up, so you've got your flood event as well as your coastal erosion. So
yeah, that's all of them on now.
Thank you. So what, even though it's largely there's a lot of flat land there, what we see is that it's flat land that's higher than it may appear to be to the untrained eye. And as Councillor Vincent says in the chat box here, that's very reassuring. So thank you for that. Also, just if you could leave those same layers. Sorry. I've got a different but slightly related, because it does link with today, another piece of work that Council's got going on. Could you just fly over the distal spit, the spit which is out just across the water from Mangawhai, that sandy bit? Yeah. I don't know if that's been mapped. So if you could make that a bit more towards the moon, sorry, so that we can see. Yeah. Thank you. So so that's your sea level rise map bit, and you can see there somewhere, in fact, near where Kyle's mouse is of course where the cyclone bowler breach was, and you can see here that with that sea level rise situation, that there is still absolutely a risk for all of Mangawhai here, that ocean would come through in that narrowest piece again. But thank you very much for showing that. Part of the reason I'm looking at that is because just right now we're putting in a submission regarding the sand mining of the coast there. Putting a submission against opposing the sand mining. And I'm very, very concerned about what's happening here. So if someone could do a screenshot of that, that'd be great, because I'd like an image of that as well. Thank you, possibly to go with the submission. The great tools. Thank you. Ian, back to you. Thank you. Councillor De La Varas, would question for clarification.
Yes, thank you, Mr. Mayor. Ian, my question is about overland flow paths. I know that, can you talk about how that might interrelate Is that taken into account at all?
Yes, that's obviously that's a really good question. Overland flow paths provide an important function in flood management. Underground systems can only accommodate a certain amount of stormwater, and that's in urban areas, and of course in other areas, overland flow is important. It's certainly something we'll be considering in there, and through the development of provisions. It's also something that is managed by the regional council in terms of that. So there are certainly some hazard provisions that include the management of overland flow to make sure that those paths the capacity is retained, because blocking overland flow paths can be just as significant as building in a floodplain and losing flood storage, of course, because you might be directing water elsewhere. So certainly I would anticipate, and that's a matter of detail that we'll get to, but I would anticipate that the provisions will provide or ensure the appropriate management of flood waters, both in terms of floodplains and overland flow paths, that you are not creating or increasing problems on other properties and things like that. So we haven't got down to the detail of exactly how that'll be done, but certainly I anticipate that the provisions, particularly around subdivision, of ensuring that future development is not altering flow paths in a way that is negative to other people or increasing flood risk, would be a part of those provisions.
Thank you.
Thank you. Thank you. Are there driving this machine? Are there further questions at this point? No, right. We'll carry on. Ian, please. Thank you.
So here, as I say, we're in a relatively early stage, and there's a spectrum of risk, there's a spectrum of control. The general approach, and it's fairly common at a high level in most plans, is that there's a risk-based approach. Some plans have taken a very quantitative approach, but that's a very challenging approach and very time-consuming and costly. But most plans take a general risk approach, so more stringent requirements in high-risk areas, and we'll come on to what those terms might mean. And certainly that's where we're keen to get feedback on that sort of approach, and mitigate risk in moderate risk areas. So getting the balance between control and managing risk is about identifying what might be higher risk, what might be more moderate risk, and the level of stringency of control within that spectrum. Seek not to increase risk and reduce risk where possible. It's pretty common in most district plans. We certainly advocate for the concept of managing vulnerable activities as part of that risk management matrix. So those activities that are more affected or more likely to be affected or greater consequence in managing risk. And we'll come on to what they may be later, and providing for avoidance or mitigation of risk. We anticipate retaining the focus on subdivision and land use. Some district plans manage land use, some manage both. From our perspective, it's really important to manage subdivision in hazard risk areas, because subdivision creates the expectation of future development and future land use. And so once you've created that expectation, it's more difficult to manage and control. We would certainly advocate that. Again, there's a whole spectrum of how you might do that, but certainly some management of subdivision. And it's not just about buildings and things, it's also about access, the ability to service. I mean, in coastal areas where you might not have any reticulated water, or water's not such an issue, but wastewater, about where you locate on-site systems and things like that, having regard to that. So those are the matters that we would be looking to manage as part of subdivision and potentially development. And incorporating performance requirements from the RPS and also the NZCPS, which specify building platforms outside of the 100-year floodplains and coastal inundation zones and issues like that. We could just move to the next one. Thank you, Catherine. One area that isn't currently managed in the district plan directly is infrastructure in hazard zones. Now, of course, infrastructure plays a couple of roles. One, it's obviously essential, but the other one, it can also lead future development. And so it's important to ensure that infrastructure is resilient and can maintain its function during hazard events. So it's a recognition that infrastructure is essential. So normally it's reasonably enabling, even in hazard zones, but provided that it is designed or constructed in a way that ensures that it is resilient. And obviously, things like erosion, where land may ultimately not be there, then you would certainly look at how you might place infrastructure. The coastal, the NZCPS certainly talks about defences against hazards and natural systems, and certainly the spit at Mangawhai is an example of a natural protective system that does help to protect. And so most district plans and certainly the RPS directs us and the NZCPS directs it is to try and protect as far as possible. There's always reasons why you might not do that, but natural buffering systems and natural systems such as dune systems, which provide a natural system and a preference for natural systems over more constructed barriers such as seawalls and things like that. And as you'll probably talk about in the climate change component about strategies for adaptive responses. Now, they work best in those areas where you have longer term opportunities to respond to climate change in particular, but also in respect of flooding and things like that, having a response that allows maybe to progressively reduce risk. That's quite a challenging issue in existing developed areas. Just move to the next slide, Catherine, please. So just talking about a couple of those, what some of those terminology might mean. What do we mean by more stringent requirements? Well, that's typically strong objectives and policies, avoiding locating vulnerable activities in high-risk areas, and discouraging other activities from locating these areas where that's possible. And ensure risk is managed and mitigated in the longer term. And I want to emphasise that longer term issue. It's really important that hazards are here to stay, and it's important that mitigation isn't a short-term solution. It's a long-term solution that protects communities, protects buildings and infrastructure. And typically the other aspect is a more stringent activity status. Discretionary or non-complying activities, pretty common for development, subdivision and high-risk areas, normally non-complying activities. In some plans, in very high-risk areas, you might see prohibited activities, particularly for vulnerable. I personally wouldn't normally advocate for prohibited, but certainly non-complying, vulnerable activities in high-risk areas. Another way of demonstrating stringency is a requirement to take under engineering assessments as part of resource consent applications. So they may be a requirement in mapped hazard areas, so that ensure we are getting the best information and to implement that. What might be high risk areas, and certainly this is something we're very keen to get some feedback on. The 10-year river flood areas, pretty high risk, particularly for vulnerable activities. And as I say, the NZCPS directs the management of risk in a 100-year horizon. Where it's probably less clear, high land instability risk. Now obviously that again comes in a spectrum. Land instability can be managed in some instances where you've got big hillside creep. It's a bit more difficult. So land instability is a not insignificant issue for the Northern District as a whole. We've done some work in Far North District Council around that as well. And the other area is the 100-year floodplain. Particularly, again, it's a matrix of vulnerable activities, less vulnerable activities, higher risk and lower risk, and where do we sit around the 100? The RPS typically directs, it does provide for development in the 100, but normally would expect to be building platforms to be outside of the outside, and that might be above, so raised above the 100-year floodplain, so the building itself is protected. Just moving on, Catherine, thank you.
Thank you. A question at this point from Councillor De Livaris Woodcock and
Thank you, Mr. Mayor.
Councillor Curnow. Thank you.
Yeah, Ian, in regards to a former briefing we had from the NRC in terms of meteorological data and weather patterns, I asked the question that the Whangarei flooding that occurred and the Westport flooding, were these 1 in 100-year events? And the answer was no, they were actually 1 in 200-year events. So I'm wondering how that excess, because, you know, obviously we're looking here at 100 years, but we're having events locally, or we've had an event locally that just goes off the spectrum here. And so is NRC reviewing its regional, you know, how does such an event trigger review of regional plan and therefore the district plan provisions or rules?
Yes, I mean, that's a very challenging issue for all councils, in that events can become larger and less frequent. And at what point do you choose to manage? It's along that spectrum of scale, really. Some councils manage to the 50-year, because that's typically what's been in the Building Act to protect buildings. It's quite specific. Most councils manage to the 100-year as being a time frame and a scale of event that it is seeking to try and manage and as best it can protect people, buildings and properties from. Some councils do go to the 200-year event and include provisions around that, but it is really difficult within that spectrum. The other thing that I should just say is that with climate change, it is predicted that these events essentially become more frequent. So what might be a 1 in 50-year event now, 1 in 100-year event now may become a 1 in 50-year event in 50 years' time, because the climate change predictions are not just about sea level rise, they're also about lower rainfall, but typically more, but what rainfall comes in more intense and higher intensity storms. So there is another climate change that effect, if you like, that is layered on what is a 1 in 100-year event. But the vast majority of councils manage, in terms of plans, 100-year, but in terms of community resilience and preparation is where you go events beyond that. So it's more about education, understanding, and getting communities to be prepared for larger events. A very challenging issue.
Thank you, Councillor Curnow.
Yeah, I'm interested in the distinction between natural defences and constructed defences. And I'm thinking particularly in our district, where a significant area of the district is protected by long established constructed defences. And to the extent, I mean, those communities didn't really exist before those defences were there. They've been there for a long time. There's management plans for expanding the scope of them. But is that going to become unacceptable? Is what reading what you suggest, it implies that it will be unacceptable to increase those defences, even though they're kind of long established.
No, certainly, sorry, and if I gave that impression, that's not the case. It's more about future, future change, and there. But the RPS itself, and certainly I think that's one area where it would be good to get some feedback on, does recognise that there are certain circumstances, particularly existing communities, that are affected now by natural hazards, and that human intervention is required to protect those communities, and against hazards that themselves may increase over time. And it's probably something that primarily sits in the regional space, but it's something that might be signalled in the district plan if particularly the council had a position on on that issue. I'm not saying would necessarily have rules, but it might be about methods with working with communities to identify those areas and looking at that. But I don't want to presuppose where council might go. That's certainly a matter I would think that council may want to consider and discuss.
Yeah, because it's those constructions already have management plans around them that communities are deeply involved with. So it just seems that the rules that are coming through in the regional plan and the regional policy statement and even the legislation are not actually acknowledging that there is this other form of defence which is well established and an ongoing community-led management process. Yeah.
And look, I think that's a really good point. And in a plan, you can signal that in a number of ways. It might be you don't necessarily need to have rules or provisions around it. As I say, you could have methods, or you could have, the introduction that recognises the importance of stop banks and drainage schemes and all of that to the community and the economic development of the community. But again, it's, I would certainly be seeking direction on where council might like to go on that.
Thank you. That's clear. Michael Day, we saw you pop into the screen there and then you've disappeared again.
Thank you, Your Worship. Yeah, so I was just going to basically say what Ian has touched on here is that in no certain terms are we looking to say no with regards to existing stop banks, and the policy directive that Ian was speaking to was primarily targeted at new hard protection structures and their appropriateness, and specifically in the mapped coastal environment, because the NZCPS has that specific direction in there as well. Yeah, that's all.
Okay. Thank you.
Thank you. Thank you. Very clear. Councillor Curnow, your hand is still raised there. Okay, all right. Thank you, Ian. Back to you. Thank you.
So these are just again where the various terminology might land. I think the focus is really on high risk. So moderate is kind of other hazard areas that don't quite get into that high risk category. I wouldn't advocate for having too many differential sort of layers, if you like. Certainly one I would be very keen on having feedback on is the concept of vulnerable activities. It's becoming more apparent in new generation district plans. And an example of that which is listed there are the types of activities. And so those are ones where people might be there, and in particular where people may have difficulty evacuating in times of event, particularly flood event. So aged or hospital type facilities, care facilities and medical facilities where people are overnight, things like that. And generally, again, it's not saying that these won't be in certain areas. It's restrictive may be that if, for example, the vulnerable activity is in the 100-year floodplain, more attention is provided and paid to access during the flooding, and ensuring that access is available and that people can be evacuated if necessary and things like that. So there's a hierarchy of approach, but as a general concept, avoiding vulnerable activities in risk areas is pretty standard. And mitigation, there's nothing surprising there. I think the key thing is that it needs to be doable, and through consent processing, that's always quite a challenge. You can have mitigation, but it does need to be reasonable, and it does need to not transfer effects to other properties. And so there are a range of considerations around, not everything can be engineered against and result in no effect. Some things certainly can, but not everything can. So it's really important that mitigation is doable and durable for the longer term. And so I would envisage the provisions will be making that quite clear. We've put some questions on there. I'm not really anticipating going through those. I'm certainly, it's triggers for discussion. But I'm happy to answer any questions that you might have, and certainly these were just there to trigger some thoughts and to focus feedback. So I'm really in your hands now as how you'd like to progress from here.
Thank you. So we're certainly wanting discussion here, but we're also needing to try to keep this work focused on the direction that's being sought, really. So there are questions for consideration here, which, if you like, trying to shape some of the edges of what we're about, which is great. This is a great slide. Michael Day, if you could just come in really regarding the direction you're really seeking from the elected members here.
Thank you, Your Worship. So specifically, we are really keen on whether council supports vulnerable activities and that as a classification with regards to a trigger for high risk activities as well, and whether I'll just put the slide back up on my screen. Direction about a risk-based approach in general, and is that supported? And further on that, what's the supported approach with regards to managing infrastructure in hazard areas as well? It's a starting point.
Okay, easy to say.
There's a lot there.
There's
a lot there
in all of that. So look, I do have a first question for you. The choice of the word vulnerable activities, is that a standard term, or is that a term that we're creating here and now with this proposed district plan? And do we want to be scaring the people?
It is a term that is used in the RPS, but not widely. It does refer to vulnerable activities, I think maybe only once or twice, so it's not what I'd call totally ingrained in there. It's certainly been adopted in Auckland, and it is being adopted in Far North. So it is pretty commonplace, becoming more commonplace as the management of hazards develops.
Yep. So those vulnerable activities that are listed are what I would call overnight accommodation spaces, rather than I'm coming to Councillor De Lavaris Woodcock's comment in the chat box that schools are vulnerable activities, but of course they're daytime places. Is that part of the distinction about what makes a vulnerable activity?
Yes, it is. Schools could be in there. I think schools, people normally, if there's flood events and things like that, people can tell children to stay home. If you're elderly or you're in hospital, you probably don't have a choice. So your ability to manage risk is slightly different. And flood events particularly would be the most severe, I think, for this sort of thing. And schools could be evacuated. Certainly people have forewarning of that event. So it is more about those ones where people don't either live there or they don't really have a choice to be there. That's the sort of focus of it, and more difficult to evacuate and things like that.
Okay, so here's a distinction for you. A boarding school where people would be staying overnight would be a vulnerable activity, but
Yes.
a day school arguably wouldn't be under that distinction, yeah? Because the people who are staying there
Yes.
in the middle of the night, that becomes an issue, yeah? So
Yes, and that's where they live. So it's about where you live and take refuge.
Okay, all right. Thank you. Yeah, there's so much in all of this. Thank you. So elected members, we're out here in the deep blue sea, really, regarding these hazards and the space of the infrastructure here, noting that climate change is the next part of this presentation that we're headed into, which also has hazards and risks here. So we're just looking right now at just simply these the approach to these mapped hazards, and looking really at this kind of infrastructure related issues really, and about relocatable buildings. It's one of the things, so I'd like to provide some direction on that. I think that there should be a direction towards relocatable buildings in the river flood and coastal sea level rise zones, rather than permanent brick buildings and solid buildings. That the houses, and that should be part of the adaptation planning that's taking place. But we need to pivot away from those solid houses. Yeah.
Yeah, and there are some examples of councils that have done that. Tauranga, I think, comes to mind, where there is provision that enables then coastal land in particular to be managed or used for a while with the recognition that at some point might need to be some retreat from that.
Yeah.
Yes, and if I could jump in, Your Worship, that tends to be in the context of coastal erosion zones and coastal erosion hazard risk as well, and often, for example, there's a requirement in coastal erosion hazard 1 areas, which is essentially erosion areas in the next 50 years. Any new buildings in those zones have to be relocatable, so they can be shipped out if necessary when the time comes as well.
Yeah. Of course, in Kaipara, we have a great history of relocating wooden buildings and houses. Aratapu, the great kauri timber company city near Te Koparu, was all shipped away, put on barges and taken away. So, and that was nearly 100 years ago. So we've done it before, and it's part of the Kaipara way, I would say. One of the challenges that we have, if you like, is that definition or the sense of the buffer on the coastal line, or what exactly is being talked about here with these hazards, and how, because it's not just exactly where the salt water hits the land, and how that's defined. And also, as Councillor Curnow spoke to earlier in her questioning, the notion of engineered responses and engineered floodplains that we have, and how all of that works regarding that coastal, the margin that we're talking about here.
Catherine, sorry, Worship. I'm just wondering if Catherine could put the slide back on, because we would like some direction with regards to whether the elected members would like this chapter to specifically focus on flood risk and coastal hazard risk, or also include wildfire risk and other hazards as well. So that's a key bit of direction we're after as well.
Yes, I might just touch on wildfire as well. You know, there's currently a risk-based approach that is adopted, but it's very difficult to implement in rules. A lot of wildfire, which is fire typically in areas that are not in reticulated areas. I mean, you can have household fires, of course, but wildfire tends to be more in the rural area or on the periphery of townships, where it's on that rural boundary. And certainly, you know, the approaches are generally specifying access for firefighting services and water storage requirements where you're not reticulated, setbacks from vegetation, but both of those are very difficult to apply. Well, you can apply them strictly, but it's a very high level of control. and very difficult to ensure compliance in an ongoing sense. I mean, if someone has water and it's a drought, they're going to use it. They're not going to reserve it for firefighting purposes. We would generally advocate that it's a matter that's looked at in subdivision, you know, around water and water requirements for that area and ensuring access and things like that. So those matters are taken into account in the future, but it is very difficult from a land use perspective. Some councils have been more restrictive in that and tried to control it and have mapped high risk areas and things, but generally most councils, it's around subdivision and potentially rural controls and rural zones around that.
All right, thank you, Councillor Curnow, then Councillor De La Varas Woodcock.
Can someone else go first? Because the neighbour's just mowing the lawn. I just need to go and shut some windows.
Okay, Councillor De La Varas Woodcock.
Yes, I've taken some notes. So my signal is to the planning team with our development of this district plan is to strongly focus on subdivision risk and preventing a loss of investment for people and resources. And so to really use whatever tools with mapping that we can do to identify the flood path, recognizing that these increasing intensity of rainfall events are going to cause so much more water traveling over flood paths rather than through our stormwater infrastructure system. And I'm thinking of, I'm always a risk averse person. I've grey hair, wrinkles, I do imagine the worst. And so, and I also remember events such as Hurricane Katrina. And so, you know, the terrible disaster, it was hard to get people out. And so I just think whatever tools we can use, and that's why I thought about schools, because, you know, there can be a number of children, many of them, and I'm thinking about helicopters, airlifting. So whether or not that requires a landing pad in a vicinity of where there's a highly developed area, I'm trying to think that, you know, we need to prepare and be really, you know, just imagine scenarios and make sure that our district plan answers to what we used to think of as being unimaginable. We actually shouldn't restrict ourselves like that. We need to be really responsible for you know, for the conditions that we find ourselves in and responsive to that.
Thank you, Councillor De La Varas Woodcock. Thank you.
Final point is on wildfire. If it's possible to have provisions that or rules that the fire breaks are not just relying on the roads, on roading, because I'm aware that, I'm not sure if this is true, but I have heard that there's no compulsory rules to create fire breaks in exotic plantations, and that's a risk in my opinion. So I think, yes, definitely we need to consider perhaps in our, you know, what is it, rural development areas, settlement areas that are adjacent to plantation forestry, that there is adequate provision and rules for compulsory fire breaks.
Thank you. Thank you.
I might just address that, if I may. Last one, what we will do is we need to look at the National Environmental Standard for Forestry, and we'll just check in there about what that has around those buffer areas and fire breaks, and then we can have a look at whether the district plan should be more stringent than those. So there is the NES that will control aspects of forestry development.
Thank you. Thank you. Thank you, Councillor Curnow, then Councillor Withy, then Councillor Wills. Thank you.
Thank you. Yeah, I managed to block out the lawnmower now. Challenges of working from home. Okay, so yeah, I do support the risk-based approach. If it was possible, and I think Councillor Vincent has mentioned about risks not existing in a vacuum. So if the district plan could look at an integrated risk management approach, so that we are looking at the whole a package of how risks affect each other. I do support the idea of vulnerable activities, and I would like to see the risk of tsunami included, because some of our communities are quite vulnerable to tsunami risk. And yeah, if it was possible, if we're going to take a risk-based approach and one step further, an integrated risk-based approach, then part of that is to also acknowledge the ability to manage risk and mitigate risk. And so, yeah, I recognize that that becomes really challenging in an environment where we're used to having rules. But yeah, if we're going to go down the risk approach, then I think we need to go integrated and managed risk acknowledgement. That would be my thoughts. I don't think I haven't answered everything, but I think that's my thoughts at the moment.
Thank you, Councillor Weddy, then Councillor Wills, then Councillor Vincent.
Thank you, Mr. Mayor. Yeah, look, I guess I tend to agree with the Mayor's comments about the high risk areas for climate change, sea level rise, or certainly on the 1 in 100 flood risk. That relocatable houses is a good option, and I certainly think that we can learn from what Tauranga has been doing there. That still continues to allow us to make the best of our productive land, etc., but doesn't mean that a lot of houses, etc., are going to be put at long-term risk. They can be relocated. So I'm certainly very supportive of that approach. On the wildfire ones, I'm a little bit more concerned about not being too restrictive and then not being able to monitor it. And I'll give you an example of that. When we looked at rolling back Chapter 4, after 18 months of debating this, there were areas in that old chapter where it was not only saying the setbacks from residential houses and subdivisions had to be quite a considerable distance, but it even went down to the detail of specifying what species could be planted. For example, one of the ones I could think was just a ridiculous situation was that Manuka was one of the ones that should be not planted near a house because obviously high resin, high flammability, etc., etc. Well, how are you going to monitor that in Northland, where Manuka is probably one of the species that's just about a weed around the place? It grows so easily and readily. I don't know. So I think we've got to be fairly taking a common sense view on this and not going to extremes. And we shouldn't be trying to specify, beside residential houses and subdivisions, what species can be planted and what degree of setbacks. Remember that all of those people are going to have houses insured. So council doesn't need to take a restrictive or a draconian approach to the vegetation issues. I think, to be fair, there's just as much of a wildfire risk on some of the grasslands if we're going into climate change where we're going to have longer and hotter summers, and we know how Northland can dry out, then we've got just as much wildfire risk there. We're not going to be able to build that into the district plan, how to control or to mitigate against a wildfire in a grasslands area. So I think we've got to be consistent across the district. So I'll just say take a cautious approach on how we approach the wildfire situation. Thank you.
Thank you, Councillor Weddy. So Councillor Wills, then Vincent, then Larson. Thank you.
Yeah, thank you. So starting from the start, I support the general risk-based approach. I'm concerned that the definition between high and moderate, that we set that fairly high, at least at this stage, because there's going to be a couple of consequences. One will be that insurance companies will be looking at our decisions, and potentially we could make properties uninsurable once we assess them as a high risk. And that also raises my concern that a couple of these topics, I don't know what the consequences are if we do agree to them. I'll use the tsunami one as an example. the last time that alert was called in Northland, I think Mangawhai had to get up and out, and all the way up the Kaipara River, including Ruawai, had to move to higher ground. If we go with tsunami level as being a consideration, that removes a huge part of the Kaipara for potential development. And I'd like to see that actually outlaid on a map before agreeing to it, because it could be a huge unintended, that would wipe out, well, it already does wipe out all of the Ruawai, but it could wipe out other settlements like Tinapai and other places that are vulnerable to a potential tsunami. Moving on, the fire one, you can't legislate against people's ignorance. We're all aware of the risk of fire in Northland. It needs to be managed, but talking about plantation forests, they actually do have legislation regarding their setbacks from boundaries and roads and power lines, which are all the major defaults to potential risk. Again, moving on, vulnerable activities. I just think that's maybe an unnecessary addition. I mean, it can be identified, but it doesn't have to be legislated, if you like. Sorry, I've just lost my control, my other computer running. The other thing that I would just really quickly want to speak to is I don't agree with broad brush identifying hazards. Our Kaipara is too much of lots of little pockets of all sorts to apply a felt pen around an area and just say it's one thing or another. And I'll give you an example of my personal experience where the regional council currently, we've got parts of our property in Tangaroa that are 30 metres above sea level, but on the regional council, they're considered floodplains. So I don't know whether we have to wait for the ARC to get it to prove that, but that's actually a consideration and you can't build on it. So they put a limitation in there without any physical inspection. I'm just raising that as a potential outcome. So I'd like to see that we do have the regional council zonings, what they call coastal in that, and we can look to use them, but I wouldn't like to see us just draw a big red line around a whole lot of the potential residential developments or settlements, as they're called in our later presentation. Thank you.
Thank you, Councillor Vincent, then Councillor Larson.
Thank you, Mr. Mayor. Just overall, I don't wish to go in a different direction to what everyone else before me has said. Probably what I have to say would segue best with what Councillor Weddy said earlier, but also with Councillor Wills in regard to wildfire. I think we're forgetting that a district plan and its rules are but one tool to achieve an outcome, and there are other tools, because the point's already been made about the difficulty of managing and monitoring any rule about restrictions on vegetation in the vicinity or the amount of water available, the storage if its areas aren't reticulated for water, when we might have another dig around in the toolbox and pull out the education tool. And it might be that, like, I don't know if this council has a welcome pack for new residents, for people to be tuned in to all the various things that what's available, what's not available in our district, and its quirks and so on. And in terms of dealing with wildfire, yes, here's a list of preferred species which tend to be more fire resistant, and here's a list of other trees which, if you really want to plant them, you need to make sure they're at least 20 metres away from your house or something like that. But it's, at least we're doing something to address the risk by explaining stuff to people. So, and someone that might spark another response from somebody else as to a means of addressing it rather than a rule and a plan. Hopefully that's helpful. Thank you.
Thank you. Thank you, Councillor Larson.
Thank you, Mr. Mayor. Yeah, I won't try to repeat anything that's already been said, but I mean, I think we have to give effect to the RPS, and we kind of takes care of a lot of the debate around what we're doing in terms of lines on maps and what have you anyway. In terms of the wildfire issue, I think we need to be careful not to conflate anthropogenic fire with wildfire. And we've had about 4 years of unraveling that with plan change 2 and 4 and got to a reasonable position in theory. The chapter is natural hazards. That means wildfires are things started by lightning strikes or such, not house fires. Thank you.
Thank you, thank you. I've got an extra question for you, and it's a question for Michael, and to lead the team here. Regarding the natural hazards, and if you consider the wonderful maps that we now have of all of the coastal zone and the river flood zone and so on and so on, the coastal sea level rise zones, and we put all of that into the mix. If you were to say people can build houses anywhere there, just say, as long as they're relocatable, how does that work? Like, all houses are allowed, if you like, but they just have to be relocatable in all of those areas. Is that permissible in the district plan? So, and then come with me on a journey and then say, therefore you can build houses or put houses anywhere on the Turawiri Straits or anywhere in those flood zones around Dargaville, if they're relocatable.
Can I offer an opinion on that?
Certainly.
I think there are two issues there. In coastal areas where you have a progressive increase in sea level and issues like that, that may be easier and more acceptable, but there is also servicing that needs to be taken into account, on-site wastewater disposal, access and things like that. Where you have a flood zone that could happen tomorrow, if you had a 100-year or 200-year flood, whether it's a relocatable house or not is almost immaterial. If you knew that there was going to be an increase in the scale of flooding and the area affected, then relocatable, yes, over time. But there is a difference between events that can happen now, albeit they're extreme, and ones that will progressively occur over a long period of time. So where I've seen the examples of relocatable, it's primarily associated with coastal. And so that concept, I think, is more, it's enabling people to use land for a period of time with a strategy to move away as the coast encroaches. I haven't really seen allowing development in high-risk flood areas relocatable, because, as I say, that could happen tomorrow.
That's pretty much exactly the response I was going to mention, Your Worship. And there is a big difference between coastal erosion hazard risk, where we know that over time the coast will start eroding by X, Y, and Z, and we can plan for that in a managed way, as opposed to floods, which could pop up overnight, and it could be a 1 in 100 year event, could be 1 in 200 year event, 1 in 10 year event. The common way with regards to managing flood hazard risk is to try and ensure that the finished floor levels are above the mapped hazard level in any event. And so that's what the RPS directs, for example, is ensuring that there's a minimum freeboard above a 100-year event of at least 500 millimeters with regards to residential activities, and that's part of the risk-based approach, right?
Yep.
And ultimately, any provisions that we put in our new plan have to be the most appropriate with regards to Section 32 evaluation as well. And so we have to look at the costs and benefits of our whole packages and actually say, is this the most appropriate package of provisions for kaipara as well?
Okay, thank you. Look, it's interesting to be teasing the edges of this these subjects, but it's very, very important work. Councillor Wills, I'm noting also that the conversation running in the chat box here as well is very interesting. Councillor Wills, then Councillor Larson. Thank you.
Thank you. My quick first question is, what's the definition of a removable house? To the staff.
Well, we would have to work through that. They're normally called relocatable, and so they are. But I couldn't give you a plan definition. Certainly, I have seen those terms used in the Tauranga plan, but I haven't delved down into exactly what you might do, because it is linked to services and access and other, not just the building itself.
The reason why that question was, I made that question, is because one of the things our plan has in place is that we don't create a ghetto of less substandard buildings that are being lived in, and that brings to mind an immediate response of what a relocatable house is. But any wooden floor house is a relocatable, because you can pick it up by definition with a truck and move it. So all you're basically removing from that potential is a concrete based floor, and even they can be removed. So I just wanted that it's a very loose conversation we're having about something that hasn't been defined. I wouldn't like to see us get in a situation where we are allowing vulnerable communities with a limited time span to put substandard housing in, because that's the only thing that qualifies on those sort of environments. So that is a concern I've got. And I also agree with the comment that was made before, really quickly, that relocatables or temporary type accommodation may work in a hazard like a coastal place where there's a potential to use it safely for 10 or 20 years, but no longer. But to put it on a floodplain where 1 in 100 years doesn't mean we wait every 100 years for it to come around. A flood will happen in that time frame, and that makes it much more at risk. Those are my so the relocatable house, it needs to be defined, and also ensures that, as the comment was made, it needs still to connect to our septic and our have potable water and all the other additions for normal. That doesn't quite meet with people's perception of a relocatable.
Okay, thank you. Councillor Larson, you had your hand up and now it's gone.
Yes, I had my hand up in error. Thank you.
Okay, thank you. Thank you. Interesting commentary here. Michael, back to you at this point. Are you satisfied with the amount of direction you have from the elected members?
Yes, thank you, Your Worship. I believe the team has sufficient direction to start drafting some good, robust provisions, and then we will report that back to you in the new year.
Thank you. Thank you. Okay, so we'll move on at this point into the next part, which is the climate change part. Yeah.
Yes, thank you, Your Worship. My suggestion here is, Catherine, if we just jump straight to the slide 38, which is 2 slides along. Key direction we're seeking here is whether there is support for introducing an adaptive pathway style climate change policy into the new district plan, broadly speaking. The previous slide also has some policy if you want to go back to that previous slide. Otherwise, we can have a discussion around the direction.
So this is interesting because, of course, we have a situation that the Climate Adaptation Act, as you've mentioned, which is the third leg on the stool of the RMA rebuild, is not even revealed to us yet about what it's out or not. So it would be a provisional approach to say to put adaptive planning pathways and to put in our draft policy into the district plan, simply because it may all significantly change into the future. Yeah, significantly changed. But the thing is, it's about the life of this plan, I guess, and it's signalling an engagement rather than the absence of engagement by the council in this subject.
That's right, Your Worship. And our council is taking a strong leadership approach in the climate change space, and we are about to embark on our adaptive pathway planning. And so what we really want to do with the district plan is just to make sure that these two work programs talk to each other and align where possible as well. That's the key approach here, is that just make sure they actually support each other and talk to each other.
Look, I think that principle of all of the parts of this actually coming together and making coherent sense is really important. I think that's a really important principle. The district has never seen this on that scale before with what we're talking about with this district plan review. Is taking us to whole new places, really. So getting a coherent part where you say, well, these bits all fit together here, and this is our take on it. I think that definitely makes sense. I would say as well that you would need to keep it at a high level so that it can be reflexive and point to all those other policy shifts that are happening further away, rather than being really prescriptive and detailed and having to provide a plan change if there were something else done by someone else, that we would actually have to do a plan change just to fit with that. I wouldn't want to see that happen in this space. But us telling our own story, I think, is an important principle. Elected members wanting to hear from you on this, please. Councillor Curnow, Councillor Delavaris Woodcock. Thank you.
I absolutely agree that climate change should be referred to and brought into the district plan and certainly considered as part of subdivision use and development. I'm a little bit concerned by going too deep into the adaptive pathways thing, because we don't really know how that's going to work and how that's going to pan out, and it's going to be specific to each individual community, and it involves a lot more than stuff around land use and buildings and things like that. There's lots of layers to it. So I just wonder, as the Mayor was saying, whether we'd be better to stay at that high level, that if you're going to do a subdivision, climate change has to be part of that consideration, and we just kind of, and that council will look at, is looking at climate change as part of our hazards management. But I wouldn't go too deep into and this is what we're doing in adaptive pathways, because we're very much in a first go, let's see how this works, let's see what pans out. We don't know what's going to come out from it, and I wouldn't want us to tie that into the district plan and get too restricted by it at this point in time. Maybe once we've done one or two of them, we go, okay, now we know how this is absolutely going to land, and we know which bits we can pull out and are relevant in the district plan. But I just think it's quite early days for us. That would be my feedback.
Great, thank you.
Thank you, Councillor Delavaris Woodcock, then Councillor Wethy. Thank you.
I think it's really important to make sure that the language we use is accessible and it's not jargon and it's people focused. So I do think it's important to put it front and centre, not be prescriptive. But I'm just reading from Kia Urito Adapt from the Treasury advisor, but he was saying that climate is going to impact everybody, and it's going to impact every aspect of life as we know it. But there are also possibilities and opportunities, and people need to be curious about that. because curiosity leads to innovation, action, and change. So I'm taking Councillor Kuno's point as not to get into complexity and detail about adaptive pathways, but not to add. Have I said what I mean to say? Put it in plain, simple language and empower our communities to think about how they can adapt and, you know, consider the impact as a reality, but without like overlaying it in terms of, you know, like doom and gloom, rather than these are the things that we all need to consider if you're going to want to build there or such like.
Thank you, Councillor Wethy.
Thank you, Mr. Bear. Well, keeping it short and simple. Yes, I think climate change should be a inclusion in the district plan, but I think where we go with it needs to be kept at a fairly high level. Adaptive pathways, I think, it's dangerous to get into anything like any detail on that, because we're guessing 6 months from now or 12 months from now, we'll have a far better understanding of what central government is directing us on that, but at this stage we can't. So I think it's got to be kept at a high level. So basically have it in, but keep it adaptive pathway, anything to do with adaptive path at a very high level. Thank you.
Thank you. Yeah, I've got something to say as well. In the climate change space, there are bazillions of opportunities ahead with climate change, not just bad things, as Councillor de Lavares Woodcock kind of indicated. And so there's a real challenge in the district plan to actually talk to only the sticks and not the carrots, if you like, and defining regarding the adaptive pathway, which is negative, rather than saying, look at all the fantastic things that we're going to be able to do in this place with climate change. And there hasn't been a document that's done that yet. Maybe the district plan should do that. And I'm being provocative in saying that, but you know, it's kind of, well, here we go with all our tropical crops. Here we go with, you know, amazing water storage. Here we go with, you know, painting a positive future into the trends that we see coming. So I just put that up there and say that it's not just about the sticks, it's about the carrots as well. And so I'm not sure how best to approach that based on the direction you're seeking. But it's certainly opportunities as well as challenges. Yeah. Michael.
Thank you, Worship. From a staff perspective, I think we've got some pretty good direction there. If I could summarise, it's yes, support for climate change and adaptive pathway response, but keep it very high level. Don't dive into the detail. Yep. That's great. Thank you.
And opportunities.
Look for opportunities.
And opportunities and fire and drought and flood. Yeah.
Thank you, Worship. Catherine, if we want to put up the slides again, we can move on to the last section prior to the lunch break.
Yay.
Well done, team. We've got through this quite well. Go next slide, Catherine. That's it, team. And just briefly, we'd just like to bring back to you the key direction which the team sought from you last briefing. It's essentially there on the screen. I'm not going to speak to it unless you request me to speak to it. It's on the screen. That's the key direction we took last briefing with regards to each of the zones. And the team's going away with that direction and finalising our drafting accordingly.
Thank you for summarising this in a very, very short space of time. It was certainly a very, very comprehensive day that we had creating this work. So, but it was also a constructive day. And so I completely expect that the work that you're showing us on this screen right now lines up with the day that we had and will line up with the document that we will see coming through.
Absolutely.
So, so I think, look, I think that's really good. Thank you for making it clear. Interesting seeing it reduced down. So, oh, ho, 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 Michael, that's from you. So it's Merry Christmas. Yeah. At that point, this point, we are at the end of the district plan review briefing and for December. So I'd like to thank the members of the public for having watched here and having joined us today. So of course, you're very welcome to join us for our final Kaipara District Council meeting, which is next Wednesday, the 15th of December, as well, a week from today. But look, just for now, I'd like to thank the entire team for having been able to join us. I'd like to thank our guests, Norbert and Ian and Kyle, for participation with us today and for the work that we've done here together. So I think at this point we're at the end of the briefing. Thank you. So I'm going to close with a karakia. And so we're doing that now. Thank you. Kia tau ngā manaaki tangati mea ngaro, ki runga ki teina a tātou, kia mahia te hua makihikihi, kia toita kupu, toita mana, toita aroha, toita rea Māori, tihei Māori ora.
Ora ora.